With the permission of Learned Director, I would like to begin today's session on Contempt of Court Act 1971 and decision-making errors for all learned judicial officers. We have Honorable Mr. Justice Ajay Bhanot, Judge of Honorable High Court of Allahabad as a resource person. Now, I would like to request our Learned Director to kindly welcome our resource person by offering khadam and memento.
Good morning to everyone present here. To today's wonderful session of today's program, we are privileged to have the benign presence of my Lord, Honorable Mr. Justice Ajay Bhanot, Judge, Hon'ble High Court of Allahabad. In this occasion, I, on behalf of Sikkim Judicial Academy, would like to extend warm welcome to His Lordship. And at the same time, it's my privilege to extend cordial and affectionate welcome to all judicial officers who have come from all districts and subdivision and present physically as well as through virtual mode. His Lordship to our officers. His Lordship graduated in law from Lucknow University in 1994 and enrolled as an advocate on 15 January 1995. Then practice in civil, constitutional, tax service, company law, and criminal side before Honorable High Court of Allahabad, and handled other matters like environment, this industrial dispute, and allied other field of law. And thereafter, His Lordship rendered his services as Advocate of Government of India, Standing Counsel, Additional Government Advocate for the state of UP and other organizations like UP State Public Service Commission at different periods in time. And ultimately, His Lordship was designated as Senior Advocate on 23rd May 2015, then elevated as an Additional Judge of Allahabad High Court on 22nd September 2017, then took office as Permanent Judge on 9th September 2019. With this brief sharing of Lordship profile, now I'd like to request Lordship to kindly guide us, lead us on the topic of today's program. Thank you.
तपाईहरुको वार्म स्वागत पाएर भने बहुत राम्रो लागेको थियो। सबभन्दा राम्रो नेपालीमा कुरा गर्नेको मौका 25-26 सालको बादमा पाएको थियो। It's my great privilege to share some of my views with my colleagues of the Sikkim Judiciary. I propose to divide as per the topics as you've seen. The first session will be on contempt of court. We all belong to the community of judges. Judges cannot be taught, but judges have to learn. And the manner of learning in the judiciary, in our judicial fraternity, is through discussions and dialogues, whether it is in courts or whether it is in the form of such of contempt, which forms the first part of our discussion. See, as judges, I always like to say we are practical jurists. Practical because we have to be mindful of the facts of the case before us, of the evidences before us, of our desire and our duty, rather our obligation to do justice in the facts of a case. Jurists, because an element of philosophy is always involved in the evolution of law. What is the standard of conduct to which individuals in a society have to conform to ensure its civilized growth? So therefore, your sights always have to be on the ground, but you have to make sure you don't get the worm's eye view. And you constantly have an elevated vision of what we call today are our constitutional values. These constitutional values have been drawn from our historical experiences and the great philosophical traditions and literary traditions, social traditions of our country. They've been very well and beautifully codified in our constitution and also explained in many of the judgments handed down by the constitutional courts. Now, as far as the law of contempt is concerned, why is the first topic called the origin, of the law of, why are we interested in that? One could simply say that you please read the act and just do your job. Why, as judges, are we interested in knowing the origins of the law of contempt? One of the reasons is that the law of contempt as it evolved was not from legislations. Its origin does not lie in legislations. It gradually evolved through judicial decision making. Now we have borrowed, in fact, though there are some instances of how our indigenous system had developed, but the fact remains that a large part of our corpus of case laws and even the statute have been derived from the Anglo-Saxon jurisprudence. So the initial origins evolved in England, to which we have all those, and that is the body which we have inherited, and then and adapted it to our own use, and as per the peculiar circumstances of our country. That adaptive process has also been a great evolution, but we are talking of the origins. So the origins have always been in the practices followed by the courts, the conventions adopted by the courts, and the case laws handed down from time to time. See, the high courts came into existence, the principle 150 years ago, and that's where the foundations of a formal judicial system as we know it now came to be laid. Now the high courts, when they were initially evolving the law, borrowed quite profusely, as I said, from British laws and the British case laws. But they were adapted at all times to the particular situations and the social realities of our own country. Initially in England and indeed in Europe, they had this concept of divine right to rule. That is, the king, the legitimacy of the king was that he was blessed by the gods themselves, which no one could dispute. So virtually it was an ironclad legitimacy which the kings and the royal rulers vested themselves with. Justice, dispensing justice has always been a very important feature of kingship. Right from Hammurabi's code, in our country also we find a lot of legal literature and the responsibility of the king to do justice. And that being the common factor, the kings orders were seen to be as divine commands, which no one... Initially, the courts were presided over by the king themselves, but then as litigation grew and the business of state became more and more diverse, more and more complex, the judicial functioning was handed over or delegated to the Chancellor in England. So it was the Chancellor who executed the judicial functions on behalf of the king. It still remained on behalf of the king because legitimacy came from the divine rights. Now it was when these courts of equity, which were being run by the Lord Justices, they started evolving the concept of contempt. They started evolving, and now that's something where it's a very important aspect of our judicial thought, and especially in England, and we have something to learn over there. See how law has grown over centuries. They were very careful in evolving laws. British courts did not lay down very sweeping propositions in the first go. They decided a case on its facts. And when they decided a case on its facts, over the years they found that while deciding, can you hear me? Am I audible?
Yes.
While deciding, they had laid down a principle on the basis of that, on which that decision was taken. So that principle came to be followed over the years, and that became what is called case law or binding precedent. Now when that binding precedent over almost centuries, that became consistent and in fact constant, the legislature statutarized that judicial pronouncement. By statutarization I mean they enacted a legislation taking advantage of those judicial pronouncements. That this is the law. For example, CRPC, you have a provision that a statement that before the police officer, that it will not be admissible in our criminal law. The origin of that is actually case law. Before it got incorporated as a legislative command. So if you see, I think there's 1915 Privy Council judgment. This was a case where one person from the frontier province of undivided India was posted at Hong Kong, and he shot dead one person. Another person, he was in the British Indian Army. So the commanding officer had taken down his statement. Now in that case also this question had arisen where they had discussed all previous case laws. So once the judicial experience and the judicial pronouncements were consistent, that see, if you are giving a statement before a person in authority who is going to investigate yourself, and you can be influenced by the promise of a reward or threat of a punishment, that statement will not be a fair statement on part of the accused. So that's how it evolved. Similarly with contempt laws. With that experience, then they started legislating. I will tell you now, even in those early days, the pamphlet, people would distribute pamphlets, 17th century, trying to scandalize courts. So that, dealing with all that gave further, it added to the corpus of case laws and judicial experience. So and hence later on the concept of criminal contempt, scandalizing the court, all that was more easily evolved and more easily settled by the courts because of that experience. And that is why the understanding of that, the whole intent behind the evolution was first to maintain to ensure that the majesty of the court, which symbolized the rule of law, is always upheld. That was the basic purpose behind it. Secondly, and I would say not less importantly, some great thinkers, Hamilton, who was one of the founding fathers of America, he's written in federal papers that judiciary is the weakest arm of governance. We don't have the purse. Treasury is not with us. We do not have the police. Force is not with us. What is available to a judge or a court to enforce the rule of law? One is the faith of the common man in the system. And that is why there's always great insistence on judges maintaining a certain code of ethics. Faith of the common man in the system, and secondly, ability to implement its writ. Because a person may be having faith, but if the court cannot implement its own writ, that faith will not be long lasting. And third, its ability to serve the ends of justice. Ex debito justitiae, that's a Latin phrase. All those incidental powers. So now coming to the Indian system, this was the past British background. I'll make a quick fast forward. So with this heritage of judging, the British decided to set up courts in India because they were also realizing that without a credible justice delivery system, you cannot have stable governance in any part of the world. So what they did was the initial high courts, they had their system of trial courts, and then they set up these initial high courts, the four what they call chartered high courts: Calcutta, Madras, Bombay, Allahabad. Now when these courts were set up, the British called them Court of Record. They were called the Courts of Record. Remember, there was no Contempt of Court Act that time, when the high courts were first set up. The first Contempt of Court Act came in was promulgated sometime, I think, in 1926, and subsequently 50 and then 71. So there was no Contempt of Courts Act. How did the courts derive their powers to punish for contempt? Because the necessity of this power we have just discussed. If you do not have capacity to implement, if you allow the majesty of the court to be demeaned, you cannot have a society run by the rule of law. So this is where they evolved the concept of the court of, again that's been evolving, the court of record possessed with certain inherent powers. When you set up a court of record, these powers are built into it. You do not need to do anything separate. So, a court of records, the elements or attributes of a court of record, one is the proceedings are enrolled. This is a definition from law dictionaries. They are enrolled on parchment for perpetual memory. That is, whatever has happened and is retained in the records of the court is the most faithful depiction of the dispute, of various aspects of the dispute. So it retains the records of the case. So that's the first aspect. Second, their power to punish for contempt. So initially these high courts were established, and when the constitution came into being, the constitution also, after the constitution also, various states also came into existence, high courts were set up. High courts remained courts of, superior courts of record. Now there is another distinction, of course there is not too much of case law, but I wish more had been written on this. What are called, there is a bifurcation of the superior courts of record and the inferior courts of record. I am not very comfortable with the word inferior courts because of our understanding of English language. The way we understand English, inferior we start looking down upon. It doesn't mean that the court is inferior. All courts, all judges, when they are exercising judicial functions, they stand at par in the comity of courts. A judge has to exercise his or her discretion independently across the hierarchy of appeals. So that's why I'm not comfortable with the word inferior, and the other thing that I'm not very comfortable is the use of the word. Otherwise, the most brilliant document which our country has come up with, the great Constitution of India, it is only the word subordinate courts. Again, as I said, the problem is with our understanding of English language. Subordinate, it means subordination. There is no subordination. We just implement the law independently. Every court, the law has to be implemented. A judge cannot go amok. But whether a young judge who's a freshly minted judicial magistrate from the academy or a very senior judge of a court of record, when they are exercising their judicial functions, they are completely independent. And that is the foundation. So that's why I was digressing slightly, was because I was not comfortable with this idea, and that has affected our functioning in a very major manner. Judicial functioning in the country, because inferior courts meaning inferior. No. But the attribute was that these courts, probably what they meant were trial courts, did not have the inherent power to punish for contempt, but they could make a reference for contempt. They could make a reference for contempt. So that was the initial, development. Now the jurisprudential basis of, as I said, of inherent powers, especially those for contempt, is to ensure an orderly, regular, and effective administration of justice. Absent these powers, you cannot expect independent and fair justice. So now I come to some of the pre-independence historical events or judgments. So, in Calcutta, the mayor's court was there, which was then succeeded by the Supreme Court, and lastly by the High Court. Then similarly at Madras, Allahabad High Court was also constituted as a court of record, which we have just discussed. And lastly, there was this pre-independence, Lahore High Court was there. As early back as in 1867, Peacock Chief Justice, Calcutta High Court, in Abdul versus Mehtab ruled that there can be no doubt that every court of record has the power of summarily punishing for contempt. So see, this is a judicial thought process which is being conducted. Every court of record has inherent powers to punish for contempt. And similarly, in 1883, Surendranath Banerjee was as Chief Justices. The power of the courts of Calcutta, Madras, Allahabad were traced to common law of England, as I have just told you. So these facts which I have discussed have been noticed in various judgments. Then in Allahabad High Court judgment, these leading cases unmistakably show that the high courts in England to deal with the contempt of inferior courts is not based so much on the historical foundation as on the high court's inherent jurisdiction. Even if there is the trial court, the high court can punish for contempt of the court. There's an interesting judgment, Privy Council 1853, which records that the Recorder's Court in Sierra Leone, the African country, had the power to punish for contempt. And the language was something like this: in this country, every court of record is the sole and exclusive judge of what amounts to a contempt of court. Sole and exclusive judge of what amounts to a contempt of court, and unless there exists a difference in the constitution of the Recorder's Court in Sierra Leone the same power must be considered to be inherent in that court. We are of the opinion that it is a court of record, that and the law must be considered as the same in that country. Then, as I said, once the constitution was promulgated, Article 215 specifically postulated. Now this is where, see, the transformation or statutarization is happening. They were established as courts of record, now the constitution comes and a pre-existing fact. The fact as court of records is already existing. It recognizes that fact and holds and promulgates in Article 215 High Court should be court of record. Every High Court shall be a court of record and shall have all the powers of such a court in. And it also felt the need to have a statutarized forms of this kind of power. Because see, when you talk of inherent powers, it remains vague. Law is also about consistency. Should be one standard. It should not be what they call was a chancellor's court. One judge say punishes for contempt for 2 years, other judge for 1.5 years. One judge lets off with a warning. So there needed to be a certain consistency, and that is what legislation brings in. See, no one is wiser than the legislature, because the manner of debate. Now, what happens in our judicial process? A judge is sitting, 2 lawyers. That is the debate. At the most 2 judges, 4 lawyers, 3 judges, a larger bench of the High Court or a constitution, 5 judges bench, 7, 8 lawyers. But the experts in the field, judicial decisions, lawyers, members of parliament. So that cannot be replaced. And that's been my experience. Respect the law. Legislature is wiser than us. We interpret it and implement the legislative mandate. So that was behind one of the philosophies behind promulgating the Contempt of Court Act 1971. Now it shows that what they were saying, that the Contempt of Court Act was somewhat uncertain, undefined and unsatisfactory. This is what the intent of the legislature was, statement and objects of there. And as jurisdiction to punish for contempt touches upon 2 fundamental rights of the citizen, namely the right to personal liberty and the right of freedom of speech and expression, the subject required special scrutiny and consideration. Very important. The legislature nailed it. And then they promulgated the Contempt of Court Act. Now see, even when the Contempt of Court Act 71 comes into existence, it exists parallelly with the inherent powers. It does not denude the inherent powers of the High Court and the Supreme Court. It only helps them in rational exercise of power. That is a fundamental challenge before any judge, rational exercise of judicial power. What are the rational considerations? What is the line of reasoning? What are the standards on which I should hand down a judgment? So, as far as the Supreme Court was concerned, that they have consistently held. There are various judgments that this is, as I said, inherent. It is not derived from the statute, pre-existing power, not recognition under the Constitution. So the Contempt of Court Act, but it helped a great deal in many ways, because it helped us to define various aspects. And when the legislature defined various aspects, including procedural issues, the exercise of powers or the scope for judicial errors also reduced, because now you have a statute. It is giving you a definition. You interpret it. So that reduces the scope of errors. And that is why. So, one critical aspect was defining contempt. That was the first challenge before the legislature. What is contempt? If a judge arbitrarily hauls up someone, can it be called contempt? So that is where the need for defining contempt. So they said Section 2B of the Contempt of Court Act. Civil contempt means willful disobedience to any judgment. Kindly notice now, as judges, now this is where willful disobedience to any judgment, that's the first thing. Whenever, now this is something which is going to assist you, say, under, when you have applications under Order 39 Rule 2A for violation of injunctions, you would be receiving many such applications. Now, 32A, Order 39 Rule 2A, again, you need greater assistance. See, the consequence of disobedience or breach of injunction. In case any disobedience of any injunction is granted or other order made under Rule 1 or 2, breach of any of the terms on which injunction was granted or order was made, court granting the injunction or making the order, any other court to which the suit or proceeding is transferred, may order that the property of the person guilty of such disobedience or breach be attached, and may also order such person to be detained in civil prison for a term not exceeding 3 months. Unless in the meantime the court directs his release. So see, whenever that disobedience is there, both the provisions have to be read harmoniously in or Contempt of Courts Act and various case laws handed down than in Order 39 Rule 2A. And what are the safeguards which the legislature has provided for the citizens, and what are the guidelines for the judicial, for the judges? So it says willful disobedience. So when we use word willful, that means intent, that guilty intent, mens rea as we call it in criminal jurisprudence, to any judgment, decision, direction or other process of a court. Now see, process of a court. So this gives you a slightly wider jurisdiction to ensure that no impediment is created, process of a court or willful breach of an undertaking given to a court. So, the advantage of legislation is, and in such matters, the words should be certain, but flexibility has to be retained by the courts. Because if they are cast in iron, if there is too much of guidelining, then also judicial discretion will be curbed. You don't know what facts are arising. So when you talk of willful disobedience or breach of undertaking, it is there, that's the start point of your judicial inquiry. This is the word, now this is where your judicial inquiry should start, whether it is willful or not. That is where you consider various aspects, that what was the judgment? What was the nature of the direction? Nature of the judgment. What was the nature of the direction which is being flouted? At times councils also give their undertaking, that we will undertake to do this. And if there is a breach of that undertaking, because that means you have abused the process of law, you have taken advantage of a court's order by giving an undertaking and yet failing to adhere to that undertaking. So that has also been made part of the statutory definition of the contained in section 2B. And the other aspect is there has to be a willful disobedience. Now, for example, now this could be, tenancy cases. The typical cases where undertakings are breached quite frequently. They come to the court, say we'll vacate, and later on the appointed date they fail to do that. So there have been instances where the tenants or the person breaching the undertaking have been committed for contempt. So that is the importance of some of the other aspects, are we to break for tea right now at 11:30?
11:45. 11:45.
So some of the, the undertakings, assurances, are some instances one particular aspect all of you have to be mindful. Is that direction plain, simple, readable, understandable? Because at times, direction may be ambiguous. So in that case, there is authority in point cautions. There are two important judgments of the Supreme Court. One is Modern Foods and the other is Mohammed Yaqub versus State of J&K. Principally what they are holding is that if there is a stay vacation application, suppose an interim injunction has been granted, an ex parte injunction, and there is and immediately the party is noticed and the party appears before the court and files a stay vacation application, then the court would well be advised not to proceed with the contempt till that stay vacation is decided, because it's an ex parte order. You don't know what the plaintiff or the person has pleaded, whether the plaintiff or has come up with facts, a frank, full and a faithful disclosure of facts or not. The court will get a composite picture. The aim of contempt is not to enforce an order on the threat by concealing facts or by blackmailing. This quite frequently happens. Then the other aspect is, suppose an order has been passed, maybe it has also been confirmed, and the order passed by the learned trial court is carried in appeal by one of the parties. There also, the case law in point says, observe caution. Now, it is not intended that a party simply files an appeal. See, typically, there is a possibility of a party filing an appeal and simply sitting over it, not prosecuting the appeal, making sure that it never comes up for hearing. See, all these, now, as I said, all these are your judicial discretion. Judicial decision making, law, development of law starts with the trial courts. So you have to observe, and when we say it is willful disobedience, conduct of the party comes in. Suppose it files an appeal and just leaves it. Then in the facts of a case, you can call upon the party and ask them that, what steps have you taken? Makes efforts. And because that is one aspect which is to be seen. If the party is making all out efforts like filing an application for listing, making a mention before the learned appellate court, then that it is taking steps. It is not that the party will be let off for contempt. It is just that the hearing is going to be postponed for a while. So these are two aspects as far as interim orders are concerned. Then the other aspect is, but they can't give you handmade solutions. Now there is another aspect, the service of notice upon parties. That is, parties have to be noticed on the order whose contempt is being alleged. That satisfaction has to be recorded by the learned court. This is the order, this is the mode of service. The court is satisfied that the order was served and hence the party has knowledge of the order and the court is initiating proceedings. Knowledge of the order by service. That is the other precaution or the caution the court has to take before, because see, these are very drastic powers, very, very drastic powers. Then another incidentally, this thing was the liability of third parties who base judgment in point. This guides your judicial discretion. Is a third party, not party to the original proceedings where the order was passed. It was not injuncted or mandamus by the courts, as the case may be. So the Madras High Court held a simpliciter defense that I am not a party will not be sufficient. If it can be established that you are aware of the order and you abetted in non-compliance. For example, say a local administrative authority is not a party. The concerned was served notice, was served copy of the order and was aware of this. It's a private dispute between, you'll be finding many, I don't know, could be a lot of disputes where to the original proceedings because it's a civil dispute between two parties. Injunction has been issued to the private party only. If that police officer has been served, or administrative officer, not necessarily, any administrative or person in authority has been served. Or for that matter, of course, you do not have organized crime in Sikkim, as we were discussing with Director Saab. In other states, there is this concept of an organized crime. Third party, not state, not anything, just a local gangster, have a Gangsters Act, Organized Crime Act. He's interfering. He says, no, you construct. You are under my protection. So if he comes to the court, says, I am not party. The court finds that he has been served copy of the notice of the order, notice and the copy of the order. He is aware of the order, if that's the judicial finding. And on facts, it also finds that this man is actively abetting violation of the orders of the court or actively instigating disobedience of the orders of the court, then this defense will not be of any avail. See, the purpose is to serve the ends of justice, and that is why it's a beautifully written judgment. I'd like to quote it. So we can thus clearly see that the courts in India invariably accepted the law applied in England and found that a party to the suit, if he had notice or knowledge of the order of the court, notice or knowledge, and a third party or a stranger, if he had aided or abetted the violation with knowledge or notice of the order of injunction of civil contempt, and otherwise found a third party guilty of criminal contempt if he has been found knowingly obstructing implementation of its order or direction. So that's how this is a very important judgment for the purposes, I think, 91. Yeah, 91, Madras 323. So see, these are a lot of, issues. One great thing about, our judicial discourse has always been the comity of superior courts, because there are so many problems which keep arising. Every decision cannot come from the Supreme Court. It is not possible. Because the huge population, huge, various reasons. A lot of people don't go to the Supreme Court on many issues. It's simply litigation fatigue or whatever. So that is the importance of the High Court pronouncements. And that is why the Committee of Constitutional Courts was created. How it is evolving is a different thing altogether. But as I said that, for example, this judgment of the Madras High Court. Now, mere knowledge. Now again, as I said, now this third party is a tricky area. third party, which is a person who's not a party to the original dispute, and taking out contempt is something on which, of course, all orders judicial mind has to be applied, but here you have to be cautious and conscious about these issues. Now, in Delhi High Court, CL Jain Woolen Mills versus Anand Bodia, this 1997 All India High Court cases 3623. The High Court directed the Customs Authority to release a consignment. The Customs authorities were directed. Consignment was in the possession of the Shipping Corporation of India and Container Corporation of India. They were not parties to the original dispute. So the High Court held this Shipping Corporation and the Container Corporation of India had claims for demurrage charges because the goods were being stored, so they had to be paid demurrage charges. And the order of release was passed behind their back. Now see, there is a difference. In the Madras High Court, he was not a party to the original because that was with the municipal corporation. But he was found guilty of willfully abetting disobedience of orders of the court by demanding the fee from the petitioners in whose favor the order was passed. Now there is again another judgment of the Calcutta High Court. This is Gopal Chaudhary Biswas versus State of West Bengal, 1973, Calcutta Law Journal 189. Again, this is a very, see, a lot of case laws you will be finding, and that's what I always encourage my colleagues and my colleagues from the judicial, judges from the judicial services, not only Supreme Courts but all High Courts also, because make sure that you are regularly reading, because that is going to widen your perspective. That is actually going to help you develop your judicial thought and refine your judicial approach from High Courts. Because a lot of cases don't reach. The aim is not to follow a judgment. The aim is not only to, I wouldn't say not follow a judgment, the aim is not only to file some case law and write it in your judgment. Aim is to do justice. And that is why a broader reading is an imperative of all High Courts. All High Courts. Now see, this is an interesting case, 73. An interim order was there directing the district magistrate, SDO and other police authorities to ensure safety of the petitioners' movement so that they could attend to their duties. Now there were other parties who were not, persons who were not parties to the petition in which this interim order was made. Interim order was to permit these persons, to give them protection to attend their duties in the factories. Because if you remember, those were times a lot of strikes used to happen. A lot of strike action was happening. No, it has decreased quite a bit. So the court issued an interim injunction that the state authorities will ensure that they can go to work and attend to their duties. Some respondents who were not parties to the original action, they started preventing the workers in whose favor the injunction was granted from attending to their duties. Now the High Court held a person would be liable for contempt, now this is important, even if the injunction does not in terms prohibit any action or impose any obligation upon him. See, the persons or the elements who were preventing the worker, there was no positive direction upon them. So even that could inappropriate facts, of course subject to your judicial inquiry. If it is established that the action renders ineffective or frustrates an order passed by the court. So, the order of the court was to permit the workmen from joining their duties. The persons who were preventing the implementation of the order were not parties, but they were aware that and there was no positive direction on them. They were aware that by virtue of this action, the High Court's order will be rendered a nullity. It will frustrate the order of the High Court, and hence they were held guilty. So this is the scope of your inquiry. Whenever you are faced with these, it has to be a fairly detailed inquiry on these lines. And if you correlate it, see, the word is willful. So a person, the Contempt of Court Act doesn't say that only against the party it will be initiated. So here a person is willfully preventing them from entering office. It is not the state authorities who are parties, but other elements. They were found guilty. So whenever these are certain, this is the line of inquiry. Again, the courts have always emphasized, like the civil appeal decided by the Supreme Court in Ram Naran versus Ramesh Naran, civil appeal 366 of 98, decided on 19th of January 21. It says that the intention behind the contempt plays a major role. What was the intention and how is it going to impact the judicial process? These are two aspects which you have to see. Individually, only the factor of non-compliance by a person should not be found the reason behind disobedience, but the court has to be satisfied that it was done willfully. That is a satisfaction that the court has to record. Willful. Now that is a legislative command, willful disobedience. So the court, after taking out such inquiries, this was the order was served, this was the mode of service, this was an explicit direction. This was the conduct of the party against whom contempt is being alleged. This conduct has been established. And now, after it has been established, you will have to find that this was a case of willful disobedience. That finding will have to be there of willful disobedience. Suppose it's a case of a very, as I said, the ambiguity is there, or order is not very clear. Then you will have to see that yes, it is not a very clear order. At times, all sorts of orders are passed. I don't have to bring out those orders before you. You are all aware. At times we are not very clear about what we are writing. So the party will not be penalized. That is a very important aspect, clarity. Second, an interpretation of the order. Again, this is a corollary of the first thing. Suppose the order is capable of more than one interpretation. More than one interpretation, he feels, no, this is what it means, this is what it means. Now, I'll give you an instance, no names and no quote. But this is an order as a lawyer I'd seen. The petitioner shall not be superannuated. But in case he is superannuated, he shall be superannuated in accordance with the rules. So, and contempt was taken out. See, now contempt is for officers. What happens is, and that is what you are, as judges you have to realize. it takes its toll on the officers because it's a criminal proceeding. You can understand the impact on a person's life and career if a man goes to jail. The Constitution has confided the power to protect liberties in all of you. You know, one of our senior judges, Justice Devendra, my Lord Upadhyay, he likes to joke that whenever we are addressing our colleagues from the judiciary, says that in our country there are 36 crore Devi Devtas, and we also acknowledge that the divine function of dispensing justice has been vested in you. So he says, today I am just seeing 3 and 6 and 9 Devi Devtas before. So that is, so you understand the nature of your power of justice, and this is one very critical facet of your power which has to be exercised if it has to be, because if you abdicate, you will fail the Constitution. And if you act beyond the confines of how the law has evolved or the legislative commands, the judgments of the superior courts, by superior courts I mean courts of record, high courts and the Supreme Courts, there will be a miscarriage of justice. So every case you have to take out these inquiries in a very deliberate manner, just as you pass all orders. Now this is again a very fine thing. This is All India Anna Dravida Munitradam versus L.K. Tripathi. This is 2009 volume 5 SCC 417. A very beautiful observation by the Supreme Court. A contempt of court is an offence of a criminal character. A man may be sent to prison for it. It must be satisfactorily proved. To use the time-honored phrase, it must be proved beyond reasonable doubt. See, these are criminal proceedings. You will apply the standards of criminal law beyond reasonable doubt, not preponderance of probability which you use in civil cases. It is not proved by showing that when the man was asked about it, he told lies. There must be some further evidence to incriminate him. Only some evidence is given, then lies can be thrown into the scale against him. But where there is some other evidence as well, when there are two equally consistent possibilities, as I said, ambiguity, there are two equally consistent possibilities, and you find that no, there has been an injunction, the order has to be passed. Because this is where it is on this foundation that our administration of justice, on this one act, very well versed in the manner of the inquiry which you have taken out, which you have to take out, and then rule on the same. Now, the second feature which we were required to discuss was criminal contempt. Now, criminal contempt again has been defined in the Act. That is the advantage which we have. See, whenever you are faced with a statute, go through the statute first. As judges, I'll tell you of an incident in Calcutta High Court. This is one of our judges used to tell us. Very senior counsel taken out the CPC, and he was reading out the provision before the judge. So the honorable judge told him, he says, look, we've read this provision so many times, why are you placing it? So he says, please go through the provision. None is wiser than the statute. So whenever you are there, please go through the provision again. None is wiser than the statute. Every time, now this is what is judicial insight and experience. Every time you will read it in the context of a subsequent case or in the facts of a case, you will find statute speaking to you. It will be guiding your judicial discretion. Do not, we get used to provisions. Bail aaya, acha, kya hai, what is the rule? All right, bail. Judicial discretion cannot be exercised in a mechanical manner in every single case. And that is the distinction. Because subject to an appeal being filed, your orders are final. So contempt, criminal contempt, again, we have the benefit of the the legislative definition. Criminal contempt means publication, whether by words spoken, written, or by signs or visible representations, or otherwise. Now the word otherwise is again of a very wide ambit. So this is the legislative intent to show you that your powers have not been bridled. And if you see the Constitution, the first promise the legislature, our founding fathers made was, we people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political. That's the first promise. Justice. In fact, in one of the judgments, I was dealing with, it was in fact a bail matter. The man came to the High Court for bail for the first time after 9 years. So I said it's a very serious matter, because the presumption will be that he did not have legal aid if a man is not coming to the High Court for bail. So I wrote that injustice is the birthmark of a slave nation. Justice is the birthright of a free people, and our constitution says they shall have it. And it was in that context that I interpreted the Legal Services Authorities Act, that a presumption will be drawn by the Legal Services Authorities if a man does not come to seek bail from the trial court or the High Court within a reasonable period of time, that he does not have legal aid or legal advice or whatever. So see, criminal contempt means publication, whether by words, spoken, written, or by signs visible or otherwise of any. So why I was emphasizing the word otherwise was, justice is the foremost promise under the Constitution. And it is here the legislature, the parliament has vested you with the powers, very wide powers, to be guided by the law which has been laid down from time to time and upon your interpretation of the law, or otherwise of any matter or the doing of any other act whatsoever, any other act which scandalizes or tends to scandalize or lowers that, or tends to lower the authority of the court, prejudices or interferes or tends to interfere with the due course of the judicial proceeding, or interferes or tends to interfere with, or obstructs or tends to obstruct the administration of justice in any other manner. So if a judge is sitting and he's not being allowed to proceed for some reason, then you do not have to look. Suppose the lawyers are standing, he says, "We will not let you proceed." I know Sikkim is a beautiful, very calm state, no one will do that here. But there have been instances where lawyers have tried to prevent judges from discharging their judicial duties in other courts. And the judges have drawn up a case, profile of the incident and referred it for contempt. And the lawyers were punished. Many instances. The advantage was of, and see, legislative enactments give further legitimacy to actions of the court. Suppose the court, this act was not there, and the court after so many, even after 50, 60, 70 years of independence, was punishing. then the argument could be that this is an arbitrary punishment. See, in the legal fraternity we are conscious, every fact can have various perspectives. But legislative command gives the judicial process, vests it with a lot of legitimacy. And see the words. Otherwise, generic, wide interpretation, liberal interpretation, as far as the act is concerned. But then it is on the facts of the case that you have to determine as to how, and be very specific. I think it's about 12, so we will be rising. 14.
Just wait, now it's your TN was just wait.
Of course, the judges always had the benefit of authorities which said that, how a person is to be proceeded against. That was through judicial life, framing of a charge, clear-cut charge. That is again limitation, framing of a charge. These are all safeguards which have to be adhered to very strictly. So, if I can just sum up as far as the contempt part is concerned. What are the salient features? First is, it is the most indispensable power and the sole power which vests in the courts to ensure the rule of law, to ensure the majesty of the courts, and to retain the faith of the public at large in the ability of the courts to get orders implemented. That is the importance of this power, and all of you exercise it in some form or the other. Second, it is a quasi-judicial proceeding. Standards of evidence are beyond reasonable doubt. Third, due process has to be followed. Due process means full deliberation, framing of a charge. Then your findings on the nature of the order, the proof of service of the order, the nature of the disobedience, and whether it has been established, and then whether it is willful disobedience or not. These are various aspects which need to be considered. Another aspect is that our courts the case literature on point, which emphasizes that this power should be very sparingly exercised. It's a very huge power that is vested. Huge power means huge trust. Trust in your abilities, in your ability to go through the due process, to return findings, to appreciate evidence, to know the law. So the courts, because if it is exercised in a frivolous manner, see, just the issuance of a notice to any person, a contempt notice. I have known of cases where under threat of contempt, orders which could not have been sustained have been implemented. So that is why due process and the manner of exercise has to be done with the benefit of the huge judicial experience which is existing in the form of case laws. When we say it should be sparingly exercised, we do not mean that or give you an incentive to abdicate your powers. That is another extreme. Our judicial thought oscillates between the government of India. And typically the decision making used to be initiated at a lower level, with the note being prepared, then the note being discussed and it keeps on moving up. Here as judges you have to do everything yourself. And at times, you find a lawyer is not prepared to argue. See, there are so many times. I'll give you an instance. There was this counsel who stood up said that this case may be taken up. Man is in jail for 7 years. I said, yes, what is the ground? What is the status of the trial? So I asked them, a thick file. Obviously, a judge can't go through the whole file, otherwise you'll end up doing probably one case in 3 days. Thick file because we had the records of the trial court. So I said, what's your ground? I died. And the man was in jail. But when I looked up the records, and of course the counsels also whom I had appointed, they came up and pointed out that the lady was an expectant mother at the time of her death. She was under hospitalization. She was undergoing a gynecological treatment. And her consulting gynecologist was present. And the cause of death was heart attack. Can you imagine? So, as I said, as judges, you will not have the benefit of so many undersecretaries sending you notes, correcting notes. You might have to, and that's what our judgments also say, that the judge will have to proactively inquire and reach the truth. Just can't sit stone-faced in the court. He is not arguing. I can't pass any judgment. That option is not available. Because if judges in India start following, maybe in England and all high commercial disputes you can say that. Everybody is well equipped. So, you see, these are, and the problems in our country are too complex for the judges. We just cannot abdicate. As I said, sparing exercise does not mean abdication. That I'm not going to do it at all. It is just that we have to be better prepared to handle this. So we'll meet after 10 minutes, if it is possible. With the director. See, there are two aspects to contempt. One is under the Contempt of Court Act. The proceedings are taken out before the High Court. And if the court feels, the trial court judges, if they feel that there is a contempt, that reference can be made. For example, a criminal to the High Court make a proper statement, describe the incident and send it as a reference. So that the High Court then proceeds with the contempt. That is, but as far as Order 39 Rule 2A is concerned, please go through that. That power is vested with the trial judge. Kindly see. Consequences of disobedience or breach of injunction. In case of disobedience of any injunction granted or other order under Rule 1 or Rule 2, or breach of any terms, of any of the terms on which the injunction was granted or the order was made. So the first is, in case there was a breach of the order, the court granting the injunction or making the order, or any court to which the suit or proceeding is transferred. So the first is they describe the ingredient. What is it? Breach of injunction, the terms of the order first. Then the second part vests the jurisdiction. Jurisdiction in which court? It says the court granting the injunction or making the order, or any court to which the suit or proceeding is transferred may order the property of the person guilty of such disobedience or breach to be attached. Now this is an advance on the Contempt of Court Act. So it is in addition. And may also order such person to be detained in civil prison for a term not exceeding 3 months, unless in the meantime the court directs his release. No attachment made under this rule shall remain in force for more than 1 year, at the end of which time, if the disobedience or breach continues, the property attached may be sold, and out of the proceeds the court may award such compensation as it thinks fit to the injured party, and shall also pay the balance, if any, to the party entitled thereto. So now this is, it is the court which grants the injunction. But then the scope of the power is not in any way lessened. If not, it is more, because you can attach the property also. The character of the proceedings does not change. It remains a criminal. See, you may grant as injunction on the civil side. But when a contempt proceeding is taken out, it becomes a quasi-criminal proceeding. It is independent of the earlier order. So that's an independent proceeding. You take out those proceedings, and the advantage of the case laws which we have discussed is that you can guide your discretion, or you can guide your judicial inquiry accordingly. The case laws of contempt of court, they help you in the procedural aspect, fair procedural aspect, second line of your inquiry. Before you make a finding that there was disobedience and therefore I hold the party guilty of contempt. So these are two aspects that needed.
Just to
Yes.
this first